Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have a case from the Fourth Circuit Court of Appeals holding that live streaming is a protected First Amendment activity. Not a surprising result, but an interesting case. I'll have more in just a moment. So Dijon Sharp was a passenger in a car that was stopped by some police officers in Virginia. And during the traffic stop, he pulled out his phone and began to live stream the cop stop. And this apparently upset the police officers, who told him that the city had a policy against live streaming police stops, traffic stops in particular. And the reason for the policy was that it's officer safety, that if people know where something is going down, they can show up and harass the police officers. Which on its face seems somewhat reasonable, but as someone pointed out in the comments here not long ago, officer safety is used to cover a wide swath of behavior that may not truly impact officer safety. So here is what the Fourth Circuit Court of Appeals said the questions were in this case. This case asks whether a town's alleged policy that bans video live streaming certain interactions with law enforcement violates the First Amendment. It also asks whether a police officer who, during a traffic stop, attempted to stop a passenger from live streaming the encounter may be successfully sued under Section 1983 for violating the passenger's First Amendment rights. So that's a fairly important question. Both of those questions are important. The first one, I think, is perhaps more important, whether or not it is covered by the First Amendment. Here is what the court says in its introduction to the opinion answering those two questions. On the first question, defendants have thus far failed to establish that the alleged live streaming policy is sufficiently grounded in and tailored to strong governmental interests to survive First Amendment scrutiny. So we'd vacate the district court's order declaring the policy constitutional and remand for further proceedings. But on the second question, we affirm the district court's order holding that qualified immunity protects the officer. When the stop occurred, it was not clearly established that the officer's actions violated the passenger's First Amendment rights, so qualified immunity bars the claim. So one of the many benefits of being a police officer, I guess, is in addition to being shot at, bled on, puked on, and everything else that happens during some traffic stops. One of the benefits is that if you cross the line and violate someone's constitutional rights, that you are qualified immune. In other words, you have a qualified immunity, and that immunity is qualified by whether or not the right that you violate is firmly established. Now, here is where I take a little bit of issue with the court in this particular case. And we'll talk about that here in just a moment. And I think it's really important to talk about the qualified immunity issue. Here's what the court says about that issue. Sharp also appeals the district court's dismissal of his individual capacity claim against Officer Helms. He asserts that it was clearly established that Officer Helms' actions violated his First Amendment rights. So, he says, Officer Helms is not immune. We disagree. At the time of Sharp's traffic stop, it was not clearly established that the First Amendment prohibited an officer from preventing a passenger who is stopped from live streaming their traffic stop. Officer Helms is therefore entitled to qualified immunity, and Sharp's individual capacity claim was properly dismissed. One of the things that I think circuit courts do, and they do very badly, is they apply the wrong level of generality to claims like this. It has been well established in numerous cases that people have the right to film police officers in the normal discharge of their duties. In fact, an Illinois statute that was passed that prevented that was indeed ruled unconstitutional. And of course, the reason it was ruled unconstitutional is because there are reasons why people might have an interest in videotaping and publishing what happens in a traffic stop. You might think about George Floyd here and other episodes where police have gone a little bit off the rails in dealing with someone. In this instance, I think the court looked at the question incorrectly. And by that, I mean it is not I don't think it's a big jump from videotaping police to live streaming police. Now, I understand their rationale that somebody could figure out where the traffic stop is going down and rush down there to harass the police. But you know, the police have radios, and the police can get other police there pretty quickly. And if a riot starts as a result of the traffic stop, well, then there will be a lot more people going to jail than just the guy who's in the traffic stop. So there are some concerns, I guess, realistically concerns about the officer's safety, but I think in large measure those are mitigated by both technology and training. And I also think that it is actually a service to videotape police encounters because, one, it keeps the officers honest, and two, it keeps the people who edit the badge cam footage honest. If you look at channels like Police Activity and Code Blue Cam, you will notice that a lot of the critical incident briefings have edited body camera. In other words, a traffic stop might go on for 30 minutes, but you only see 4 minutes of the traffic stop, and usually that is indeed the most exciting and most applicable 4 minutes. But it still is a question of what context is missing. One of the things that Donut Operator, another YouTube person on here, does is he provides that context when people use a cell phone to show 3 minutes of video from a traffic stop without showing the entirety of what went on before. I think context is important, and for that reason, I think that indeed, the court got the First Amendment question right. There is a First Amendment right in doing that. I think it got it wrong when it applied the wrong level of generality, saying, well, even though videotaping has been established, we haven't decided live stream, so it wasn't clearly established. I think that is just it's looking too far down in the weeds to find an out for the police officer. The other claim that is at issue is whether the town's policy violates the First Amendment. And the policy was at issue, and here's what the court said about the policy issue. Officer Helms, these are the allegations. Officer Helms tried to seize his phone upon learning Sharp was streaming to Facebook Live. Officer Ellis said that in the future, if Sharp broadcasts on Facebook Live, his phone will be taken from him, and if Sharp refuses to give up his phone, he will go to jail. Both officers justified their efforts to prevent live streaming using the same officer safety rationale. It is a reasonable inference that absent a policy, the two officers would not have taken the same course. For the same reason, nor would those officers have known in advance that Sharp would face the same treatment if he tried to live stream another officer in the future. And here, all the court is doing is saying, look, the town says it doesn't really have an official policy, but the facts seem to indicate that they do. And then they drop this footnote, that Officer Ellis seemingly claimed to be acting under North Carolina's statute prohibiting resisting, delaying, or obstructing an officer does not change this analysis. Even if Officer Ellis thought his authority to seize Sharp's phone or arrest him came from this statute, it is still a plausible inference that he could only know the statute would enable these sanctions if there was a policy to prevent live streaming. To know in advance that live streaming would be treated as obstruction or that Sharp would be ordered to stop live streaming and so faced arrest for resisting that order still suggests that there is a policy against live streaming. But of course, the court remanded that for further investigation. So here's what the court says about that. Sharp has met his initial burden by showing that the alleged policy restricts his protected speech. Creating and disseminating information is protected speech under the First Amendment. A major purpose of the First Amendment was to protect the free discussion of governmental affairs, and other courts have routinely recognized these principles extend to the First Amendment to cover recording, particularly when the information involves matters of public interest like police encounters. So, if you decide that the First Amendment protects filming, how is it any different if it is live streaming? That seems to me to be a distinction without a difference. I'm critical of the Fourth Circuit's ruling in that regard, and we'll have to see if that ruling ever gets taken up to the United States Supreme Court, how the United States Supreme Court would rule. I suspect I know that they would rule that the officer is granted immunity, but I don't know that for sure. There is a strong push among district court judges and also among appellate court judges to limit the role of official immunity. And a lot of that is pushback from things like the George Floyd incident. And I think that pushback is perhaps long overdue. Now, it is always interesting, too, to read concurrences and dissents, and in this case, there's a concurrence. And one of the judges says, well, I concur in the result, that it's protected speech and that the officer is immune. What I don't concur in is the fact that this was a Fourth Amendment seizure and the policy shouldn't be evaluated under the First Amendment. It should be evaluated under the Fourth Amendment. Now, again, that is sophistry because essentially what is the key process at issue here is the filming of the traffic stop. The video of the traffic stop is what's at issue. That is clearly a First Amendment, not a Fourth Amendment right. And the analysis that the court did here under the First Amendment is appropriate. An analysis under the Fourth Amendment in this context, I believe, would be completely inappropriate. So there you have it. That's the issue in this particular case, Sharp versus the city. And we'll have to see how this comes out later on. Since it's been remanded, there will probably be additional hearings and a trial, and we'll find out whether or not the city has actually violated the First Amendment with its policy, and whether that policy is narrowly tailored to advance an important governmental interest. That is something for another day. Thank you for listening. Thank you for watching this channel. I appreciate all of you who have subscribed. Tell your friends, tell your neighbors, tell your friends' neighbors, tell your neighbors' neighbors. Tell everybody. I'd appreciate it. I would love to see this channel grow. It'll give me an opportunity to share more insights and more information with more people. Thank you again for watching. Have a marvelous day. Be kind to people, and I will catch you on here next time. Thanks so much.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.